All right, I will call to order the Zoning Board of Appeals meeting for Wednesday, March 26, 2025 at 7 p.m. To all persons interested in or affected by the actions of the Zoning Board of Appeals, you're hereby notified pursuant to Section 11 of Chapter 40A of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that this public hearing will be held on Wednesday, March 26, 2025 at 7 p.m. Herb, do you have it to read the all of our Zoom fun stuff?
Sure. Let's see. Where did you stop? The Zoning Board of Appeals public hearing will be held by remote participation methods.
That's perfect. Yeah, go there.
Public access to this meeting shall be provided in the following manner. The meeting will be televised live via Xfinity Channel 8 or High Definition Channel 1072. May also be accessed via the Government Access Channel live stream on the Town of Barnstable's website, http://streaming85.townofbarnstable.us/cablecast public site /watch/1 channel =1. Real-time access to the Zoning Board of Appeals meeting is available utilizing the Zoom link or telephone number and meeting ID provided below. Public comment can be addressed to the Zoning Board of Appeals by utilizing the Zoom link or telephone number and meeting ID provided below. For the Zoom meeting option, http://barnstable.us.zoom.us/ looks like a J /84824907257 meeting ID 24907257. Telephone number option, US toll free 888-475-4479. Meeting ID is the same, 848-2490-7527. Applicants, their representatives, and individuals required or are entitled to appear before the Zoning Board of Appeals may appear remotely and may participate through accessing the link or telephone number provided above. Documentary evidence, exhibits rather, and or visual presentations should be submitted in advance to the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling area code 508-862-4682 or emailing anna.brigham@town.barnstable.ma.us. Call to order. I will now introduce the board members. Let's see, who do we have here? I'll start with Jake Dewey.
Here.
Okay, Herb Bodenseek, I'm present. Paul Pinard. He was present.
He's up there.
I'm here. Mike isn't working.
I'll get back to Paul. Mark Hansen.
Present.
Aaron Webb is out tonight. Larry Hurwitz is here.
Present. Yep, present.
Manny Alves.
Present.
Rodney Tufano. And Natalie Pittenger.
Two people without mics.
This is Paul. Can you hear me?
Yep.
Yes, I can.
Okay, I'm present.
Okay, so.
And Natalie, are you there?
Yes, I am. Did you hear me?
There we go.
Okay.
Now we did.
We're just missing Rodney and Aaron, I guess.
Yes.
Okay, so notice of recording. This meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 30A, Sections 20. I must inquire whether anyone is recording this meeting, and if so, please make their presence known. None heard. We have minutes from March 12th to read in. Has everyone reviewed those minutes?
I'll make a motion to approve the minutes as written.
I'll second that.
Okay, all in favor?
This is Paul
Yeah.
before the vote. I don't have the minutes up now, but I read them before. And the
Okay.
first, can you hear me?
Yes.
Yes.
The first case, I don't see a vote recorded on the overall decision. I see a vote recorded on the findings, but not a final vote on the overall appeal. Is that correct? I mean, did I read that correctly? And if so, do we need a vote on the overall appeal?
Anna, I would defer to you on that.
Why don't we hold off on approving those minutes and I'll take a look at them and we'll revise as needed and we'll put it back on the agenda next time.
Okay, so I think then Mark needs to rescind his second, and I need to rescind my motion,
I rescind my second.
and I rescind the motion to approve the minutes.
And we'll bring this back to the board shortly.
All right, Herb, I can take over with taking us into executive session.
Thank you.
All right. Appeal number 2023-010, Arista/Wendy's LLC executive session. This is for the purpose of discussing litigation strategy with respect to the case in the land court 24 MISC 00088 by Arista/Wendy's LLC for property at 715 West Main Street, Hyannis. Appealing the denial of a special permit to construct a drive-through window at a Wendy's fast food restaurant. If chair determines that an open session could be detrimental to the board and town's litigation position, we did make a determination, or I'm going to make a determination to declare that an open meeting discussion would have detrimental effect on our litigation position. And I will make a vote that we go into executive session by stating I move that the Zoning Board of Appeals convene an executive session under MGL Chapter 30A, Section 21A3 to discuss litigation strategies with respect to the Wendy's, Arista/Wendy's LLC versus the Town of Barnstable Zoning Board of Appeals at 715 Main Street, Hyannis, based on the chair's declaration that an open meeting discussion would have detrimental effect on the litigating position. And the board will return to open session to conduct the rest of our agenda after we come back from executive. I need a second.
Second, Paul.
It's a roll call vote. Herb Bodenseek,
Favor.
Paul Pinard,
In favor.
Larry Hurwitz,
In favor.
Mark Hansen,
In favor.
good Rodney Tavano. Rodney is present now. Rodney there? Yeah.
Yeah, present.
And then, are you voting in favor to go to executive session?
Yep.
Natalie Pittenger
Yes, in favor.
and Manny Ellis.
In favor.
All right. David, can you transfer us to executive session?
Yes.
We're going to a new breakout room. Is that what we're doing?
Yes.
Okay. The first order of old business is appeal number 2024-036. Hyannis Series 4 LLC has filed an appeal for an administrative official decision in accordance with 240-11A1 principal permit uses in the RB, RD1, and RF2 residential districts. The appellant seeks to overturn the order to cease and desist and abate dated August 2nd, 2024. In the notice of zoning ordinance violation letter, the chief local inspector stated that they observed a violation of chapter 240-11A1, namely an apartment created on the second floor of a building used as a lodging house. The property is not owner occupied and is not eligible under chapter 240-47-1 family apartments or chapter 240-47-2 accessory dwelling units for a second unit as of right. The subject property is located at 48 Greenwood Ave, Hyannis, Mass, as shown on Assessor's Map 289 as parcel 138. It's located in the Residence B RB zoning district. This was continued from October 23rd, 2024. We received correspondence from the building commissioner Florence, as well as attorney Alva, that due to the state housing bill, that the accessory dwelling unit bylaw will capture this. So the complaint has been withdrawn. So I believe we can make a motion to rescind or withdraw appeal number 2024-0336 without prejudice. Need a second?
Second.
Roll call vote on the rescission. Herb Bodenseek,
In favor.
Paul Bernard,
In favor.
Mark Hanson,
I'm in favor.
Larry Hurwitz,
He's gone.
Manny Alves.
Favor, but it's a withdrawal, right?
Yes.
In favor.
Rodney Tavano,
In favor.
Natalie Pittenger. Did Natalie not come back either? Oh, no, she's there. Okay.
In favor.
All right. And I'm also in favor. So that moves us along to new business. In appeal number 2025-005, Thomas C. Cochran III and Sarah S.H. Cochran have applied for a special permit pursuant to section 240-91H3, develop lot protection, demolition, rebuilding on non-conforming lots. The applicants are seeking a special permit to allow the demolition of the existing dwelling and construction of a proposed dwelling on a non-conforming lot. Proposed dwelling will comply with all setbacks, lot coverage, and will be less than 20%. Floor area ratio will be less than 30%, and the building height will not exceed 30 feet. The survey property is located at 82 Barnard Road, Osterville, Mass, as shown on Assessor's Map 140 as parcel 192. It's located in the Residence F1 RF1 zoning district. So sitting on this will be our regular members, myself, Herb, Paul, Mark, and Larry. Do you want to sit on this?
Larry jumped.
Oh, okay. We'll go next. Manny, do you want to sit on this?
Sure.
All right. Attorney Schultz, whenever you're ready.
Good evening, Chair Dewey and members of the board. For the record, Michael Schultz on behalf of the applicant, Sarah Cochran. Mrs. Cochran is the owner of the property located at 82 Barnard Road in Osterville and shown as Assessor's Map 140 and parcel 192, and is comprised of approximately 19,202 square feet. The property was improved with a single-family dwelling in 1970, according to town assessing records, and it is consistent with the rest of the neighborhood in terms of size and setbacks on the lot. In connection with the demolition and rebuild, the applicant's proposal meets all of the performance criteria set forth in 240-91H1 for the issuance of a building permit as of right, with the exception that a variance was issued between this property and a neighboring one, which altered the lot line, rendering it it's just a non-conforming lot and not a legal pre-existing non-conforming lot, which is why I'm before you this evening requesting a special permit. As noted in the introduction, we meet all the setbacks: front yard of 32, west side yard 20.3, east side yard 20.4, and the rear setback of 25.4. And if it's helpful, I don't know if you're able to bring up the site plan for the board so that they're able to take a look at it. That would be super.
Sure, 1 minute, please.
Thank you. And I'll just continue as that's coming up. that based on the following facts, I would submit to the board that the appeal 2025-005. Yep, thank you, Anna.
Sure.
And if you're able to blow that up a little bit, as the board can see, the bold line is the proposed dwelling situated right in the middle of the lot. And if you look to the far left, you can see a triangular shaped lot, and that is lot 47. That was the variance component that was granted back in 1994 that rendered it non-conforming. Based on the facts, I would submit to the board that it fulfills the spirit and intent of the ordinance and satisfies the requirement for the issuance of a special permit. First, that it falls within a category specifically accepted for the issuance of a special permit, and that section 240-91H3 does allow for the board to make the findings for a special permit. 2, the proposed setbacks on the lot must be equal to or greater to the yard setbacks of the existing building, as evidenced on the plans by Sullivan Engineering and Jim Golden, the architect. All of the setbacks are conforming. Number 3, all of the criteria in section 240-91H1, B1, 2, and 3, they're all met. Lot coverage is 17.8%, which is beneath the 20% that's required or allowed. The floor area ratio is 0.23, which is below 0.3, which is allowed. And the building height from the defined as grade to the top of the plate is 21 feet 6 inches, which is less than the 30. Finally, I would submit to the board that the proposed dwelling is not substantially more detrimental to the neighborhood than the existing dwelling. Again, we're conforming in all aspects of the ordinance. We have a letter of support from the neighbor located at 46 Rambler Road, James and Suzanne Bandana, who are in support of the application. And I would submit to the board that the design by Jim Golden, the architect, would provide an aesthetic improvement to the neighborhood. And based on that, would respectfully request that the board issue a special permit. Thank you.
Thank you. Does anyone have any questions for the applicant?
I do.
Go ahead, Manny. Sorry. Go ahead, Natalie.
Yeah. I just thought the existing situation on the left side of the house, I don't know whether that's east or west, it really looked like it was closer to 6 feet to the property line, because there was a fence there for the next door, the abutter next door. So so is the new building going to be less of a footprint than the old building?
The new building is a greater footprint, I believe, than the existing building.
Okay,
but the setback is 20 feet, right? You're at 20 feet there, I think.
That is correct. So we're conforming on all setbacks. So if you're looking at the bold line on the site plan, that distance is greater. The allowed setback is 15, and we're not less than 20 feet on either side.
Okay. Well, the existing one didn't look like there was 20 feet there. That's for sure. I mean, I was by there today, so that's how I know.
Let's see, Anna, are you able to blow that up just a little bit? I think I have it in my letter just to help you out.
Yeah.
So that existing on what we're looking at to the left would be, I can't see the distance, but 15 feet.
Yeah, it says 20 feet.
20 feet.
That's the proposed, correct.
And 19.8 right there?
From the porch.
19.8, and you can see the 15-foot side yard setback.
Yep.
And the existing garage slab, which is kind of a hatched, it does not go inside that 15-foot side yard setback. So we're making that side yard setback better than what was existing.
So what about the garage? How far is the garage from the side
That
of the
right
abutters?
there is no longer existing. Well,
Okay,
that
Okay. That's it.
okay.
So just to follow up on Natalie's question, so where it's 19.8, which seems to be the closest to the lot line, the setback requirement there is 15 feet, is that right?
That's correct.
Okay, so you're staying, okay. The other question I had is, and I read the variance that I guess made this a non-conforming lot. And if you could scroll down a little, is it total lot dimensions that's below requirement? Is that why it's non-conforming?
No. So it would have been in 1970 when the house was built, the lot contained a little over 20,000 square feet. And then in 1994, that little triangle that you can see, lot 47, that was conveyed to the lot next door, the lot to the left. And so that reduced it just below 20,000 square feet. And so what was once, when it was constructed, a legal pre-existing non-conforming lot, then became just a non-conforming lot with the benefit of a variance.
And what is it that made it, even prior to that conveyance, a legal non-conforming lot?
When it was developed in 1970, it contained the requisite size to be a conforming lot. And then in 1985, when town zoning went to 1 acre, which is 43,560, at 20,000 square feet, it became a legal pre-existing non-conforming lot. And then in 1994, with the small little carve out of that sliver, became a little bit smaller and only non-conforming with the benefit of a variance.
Gotcha. Thank you.
Just real quick. So this is a essentially a by right project. It's just that peel off took away the pre-existing.
Exactly right. Yep.
Okay. I'd like to make findings if possible, unless anybody has any.
Hold on, we have to do public comment.
Oh, yeah,
Hold on.
public comment. Sorry. Yeah.
Are there any other board members with any questions for the applicant? I mean, I get that's my only sort of the lot, for this to apply, that variance just sort of puts a little wrinkle in it all. Was it a legal pre-existing non-conforming at the time the zoning changed? Because
It was when it was developed in 1970, right? So it was shown on a plan. It was developed in 1970. It was a legal pre-existing non-conforming lot. And then in 1994, with the alteration of that lot line under 40A Section 6, you have to go, they received two variances, one for our property and one for the adjacent property. So it's a non-conforming lot with the benefit of a variance.
but a new lot was drawn at that time. It wasn't pre-existing.
Correct. And that's why it has the benefit of the variance. So that's why the applicant, the two lots went in 1994. So that lot 47, that little triangle, was conveyed out to the neighbor under a separate certificate of title. And that variance protects the nonconformity of that lot and allows the alteration of that lot line and the conveyance of that small little triangle. If we didn't have a variance, we would be what's called a non-compliant lot. So we would be an illegal lot. But with the variance, you protect that.
Yeah, the variance goes with the land.
Correct. And it's actually, kind of an interesting nuance with Section 24091, because I have suggested to planning and development that it shouldn't be a legal pre-existing non-conforming lot that has the benefit of a demolition rebuild. It should just be a non-conforming lot, because we meet all of the performance criteria for a demolition rebuild.
But that almost implies that the variance is unlawful. So it is still legal, Malcolm. It was aided by the variance to become, I guess, you're dropping the legal as if the variance had that effect.
The variance makes this new lot line that we see for lot 82 Barnard Road. It makes it legal and non-conforming.
I understand. You're just thinking it's no longer pre-existing because that means before the zoning coming into being. I get that, but it's still a legal non-conforming lot.
Correct.
I got you. Okay. Yeah.
If we weren't creating a new lot, it was
Yep.
an existing lot, right?
Understood.
Yep.
It looks like we may have lost the chairman.
Okay.
We're going to beat this to death. Let's go, guys.
Herb, can we take it to public comment maybe? Till he gets back.
Herb, you want to take us to public comments in Jake's absence? I don't think he'd object.
You're muted.
Oh, hi.
Herb.
Has Jake stepped out?
Yeah, can you take it to
Okay.
public comment?
Well, wait a minute. Who's assigned now? I mean, we have a problem here because Jake was assigned. Are we down to four?
He'll be back.
Yeah, you're right.
Okay, so we can do it with four. Okay, let's go.
Okay, I move we open public comment.
Second.
All in favor?
Aye.
I have to read through the list now. Let me find the list. Manny Alves,
In favor.
Mark Hansen,
In favor.
Paul Pinard,
In favor.
Larry Hurwitz has left, and Natalie is on this. Yes.
Yes.
So Natalie,
In favor.
okay. Is there anyone wishing to speak from the public? Hearing none, I move that we close public comment.
Herb,
I'll just you probably want to read the comment
Yes.
we got. Sorry, Anna.
Oh, we did get comments, didn't we? All right.
Yeah, it did.
Let's see. I have the one letter in support. Thank goodness I opened all this stuff ahead of time. March 24th, 2025, from Suzanne Bandanza. In favor. Reviewed the proposed plan. Believe it's in. Do I need to read it word for word? Probably not. And this is from 46 Rambler Road, Osterville. And that was it, correct?
correct.
All right.
Now we need Jake.
And now I may ask for a motion to close public comment.
Motion to close public comment.
Second, Paul.
Okay. All those in favor? Manny Alves,
In favor.
Mark Hansen,
In favor.
Paul.
Paul.
I have to read off the list, of course. Manny Alves.
In favor again.
Oh, yes. Okay. I read it out of order.
Paul Natalie.
Jacob Dewey's has left the building. Is he gone for the duration or?
No.
Okay.
This is Paul. I'm in
Natalie?
favor.
Yeah, all in favor. Paul's in favor.
And Natalie.
In
I think
favor.
I've covered everybody. Natalie's in favor?
Yep.
Okay. Public comment is closed. Now,
Now we need
I
Jake.
would move to close public hearing. Have we deliberated
Anybody have
effectively
anything?
enough on this? So I
Back to
would
the
move
board.
that
Does
we-
anybody have any questions?
Anybody?
Nope.
I'm good.
Okay.
I'll move that we close public hearing.
Second.
All those in favor?
Aye.
Jacob will say he's a yes. Mark Hanson?
Aye. Yes. In favor.
Manny Alves?
In favor.
And Natalie Pittenger.
In favor.
Paul?
Okay. Public comment is closed. And Mark, you wanted to make findings on this?
Yeah, I'll go ahead if everybody's good with that.
Good.
With regard to special permit number 2025-005 Cochrane, section 240-91H3, developed lot protection, demolition, and rebuilding on non-conforming lots. For all special permits, the board is required to make general findings pursuant to 240-125C. For the board shall review the evidence presented by the applicant, staff, and members of the public, and after weighing such evidence, is encouraged to articulate if and how the evidence contributes to each of the following requirements. Number one, that the application falls within a category specifically accepted in the ordinance of a grant of a special permit. Find that section 240-91H3 allows for the demolition and rebuilding of a residence on a non-conforming lot. Number two, the site plan review is not required for single-family residential dwellings. Number three, after an evaluation of all the evidence presented, proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. Further, section 240-91H3 requires the board to find that if the proposed demolition and rebuilding cannot satisfy the criteria established is H1 as of right, then the board may allow the demolition and rebuilding by special permit, provided the board finds that the proposed yard setbacks must be equal to or greater than the yard setbacks of the existing building. Find and has been presented that all proposed setbacks will conform to the ordinance. The proposed lot coverage shall not exceed 20%, whichever is greater. The proposed lot coverage presented is 17.8%, which does not exceed the threshold. The FAR shall not exceed 0.3 or 30% of the existing floor area ratio of the structure being demolished, whichever is greater. The existing FAR is 13%, and the proposed FAR is 23.9%, which does not exceed the threshold. The building height in feet shall not exceed 30 feet to the highest plate and shall contain no more than 2.5 stories. The proposed drawings and height for the principal dwelling, 21 feet, 6 inches, which does not exceed that threshold. Board is also asked to find that the proposed new dwelling would be not substantially more detrimental to the neighborhood than the existing dwelling. Find that it is in common type of design and size for the neighborhood. And those are my findings.
Do I have a second?
Yeah, this is Paul, second.
All in favor? Jacob, not here. Paul Pinard,
In favor.
Mark Hanson,
In favor.
Manny Alves,
I am in favor.
and Natalie Pittenger.
In favor.
And do you have suggested conditions?
I do, based on,
Wait, Mark, I think we should have Jake vote because he was assigned to this.
that's fine.
He just got back.
I just finished findings, Jake.
Okay, did you read the findings basically straight from the staff report?
I did.
Yes.
Okay. So I'm in favor of the findings as written in the staff report.
Okay. I do have suggested conditions dated staff report March 11th, 2025, and I'm going to ask Attorney Schultz if he is okay with those, but specifically number 4. Are we are we good? It's number 1 through 6, but sometimes you come back on the full build out when it's a construction project.
Yes, that it represents full build out of the lot. We still do have a little bit of wiggle room, right, with the, but I suppose, right, with the board granting this special permit, I'm amenable with those conditions. So
Okay, thank you. Those are my suggested conditions, number 1 through 6 as presented, as written.
So we need a roll call vote on the conditions. Harbonseek,
I'm in favor.
Paul Pinard,
In favor.
Mark Hanson,
I'm in favor.
and Manny Alves.
I'm in favor.
And I'm also in favor. So Attorney Schultz, you have your special permit.
All right. Thank you very much.
All right, moving along to our third and final item tonight. James, on appeal number 2025-006, James D. Clark and Christine D. Clark have appealed an administrative official's decision. Petitioners are appealing the notice of zoning ordinance request for enforcement denial dated January 24th, 2025 under MGL Chapter 40A, Section 7. The petitioners submit that the decision of the administrative official dated January 24, 2025 was in error, as the structure was erected at 968 Main Street, is not a pole supported by wires, ropes, and burlap, but was constructed by 4x4 lumber cemented into the earth, extending approximately 20 feet into the air directly on the common property line, draped with burlap, which encroaches at 978 Main Street. Survey property is located at 978 Main Street, Katuitt, Massachusetts, as shown on Assessor's Map 034 as parcel 032. It's located in the Residence F RF zoning district. So again, sitting this will be our regular members, myself, Herb, Paul, Mark, and Rod. Do you want to sit on this? All right. So I will turn it over to Jim. Did you want to get background on this, or?
No, I would give it to Attorney Schultz for the background.
Okay, Attorney Schultz, go ahead.
Good evening, Chair Dewey and members of the board. Michael Schultz on behalf of the petitioners, James and Christine Clark. Anna, if you'd be kind enough to bring up my letter, just so it does have a nice picture, at least for the board to see. And thank you. And scrolling, I think it's on the third page, Exhibit 1, the first photograph. Yes. Yeah. Thank you, Anna. Christine, the Clarks are appealing the determination of the building official, Kevin O'Neill, dated January 24th, 2025, denying the request for enforcement under General Laws 48, Section 7, which deemed the 4x4s cemented into the earth, connected by 2x4s extending 20 feet in the air and draped in burlap, that it was, quote, poles, minor incidental improvements as protective devices. I would respectfully submit to the board that such a determination is inconsistent with the definition of a structure under 240-128, and that the building department's own interpretations, and we respectfully request that the board overturn that. The properties in question, which are 978 Main Street and 968 Main Street in Katuitt, are perched high above Katuitt Bay. The Clarks purchased 978 Main Street in August of 2023. It's located very close, as you can see in this photograph, to 968 Main Street, with the second floor of the Clark property being approximately 5 feet from the common property line. I don't know if, Anna, if you're able to pull up, I'm sorry to do this to you.
That's okay.
It would be photograph number 1 of the photos. And this would show before the trees and the burlap and the walls going up, the topography. So if we're looking at this photograph, to the left is the Clark property, and to the right is 968 Main Street. The hydrangeas are on the Clark property. There's about a 14-inch area of dirt, and then there's a stone wall that drops down about 8 feet to 968 Main Street, the abutting property. And what the abutter attempted to do was to put giant green arborvitaes in a 14-inch area, and then cover that with 4x4s, 2x4s, and draping it in burlap. Beginning in late November, early December of 2023, which was approximately a year ago, the owner of 968 Main Street began to construct that wall. I reached out to Michael Gill, the attorney who actually holds record title to the property, and I talked to him, and construction halted. It stopped. It didn't continue the rest of 2023. We thought the issue was over until it began again this year. My clients made multiple attempts to reach out to the property owner, delivered nice letters to the P.O. box, leaving cell phone numbers, leaving any sort of communication, and nothing was returned. So on December 3rd of 2024, I reached out to the building department via email. I sent that to Kevin O'Neill, who is the local inspector. Inspector O'Neill did go out to the property. He took a look at it. He called me back. He said that's certainly a structure, and he halted construction when he was there. He went back to the office, and that was then allowed to continue, with the interpretation being that it was poles going up into the air supported by wires. An enforcement letter was received, a denial letter, January 24th of 2025, which has led to the instant appeal. Under the zoning ordinance, 240-128 defines a structure. And a structure under that definition, 240-128, is any production or piece of work artificially built up or composed in parts and joined together in some definite manner, not including poles, fences, or other such minor incidental improvements. I would submit to the board that a pole, I don't know where my definition went, but under Merriam-Webster's dictionary is a long, slender, usually cylindrical object. I would reference a flagpole. What's been constructed certainly is not a flagpole, is not a single pole sticking up into the air, nor are there wires connecting them, but they're 4x4s cemented into the ground and connected by 2x4s. And if you're able to turn to...
Attorney Schultz, before you leave this photograph, is this stone wall, whose property is the stone wall?
The stone wall is on the abutting property, 968 Main Street. And so the area between really the hydrangeas are on the Clark property, which is my client's property. And then that little bit of dirt between the hydrangeas and the wall, that is actually the neighbor's property where they're trying to put these giant green arborvitaes.
Thank you.
And actually the balls of, and I know it's not before this board, is to resolve trespass issues, but the balls of those giant green arborvitaes are on my client's property. If you can turn to photograph number 4, Anna, please. And this just illustrates to the board the complexity. This is looking from Katuitt Bay towards the properties. So 978 Main Street, the Clark property, is the furthest one in the distance. And you can see the complexity of what's going on in the structures that are existing. We've got 4x4s, 2x4s draped and encased in burlap all the way up the entire sideline. Let's see. And if we can turn back to my letter, Anna, please. Mm-hmm. And exhibit number 7, which is, it'll be the last page, that last photograph. So in addition to being a structure, further down, please.
Oh, I'm sorry.
Yep. Yes, perfect. So in addition to being a structure, what this does and where it's allowed to exist right on the common property line encourages trespassing. So what we're looking at here are two individuals. What they're doing is they can't even maintain or build their structure without being on our property to do so. So if I were to go to the building department looking for a shed or to build a pool, I know that Brian and his department have been extremely lenient on, let's say, a pool or a shed. you can't build it directly on the property line, but you can build it, let's say 5 feet back so that you can maintain that structure on your own property. What's been allowed to exist here is they're forced to come onto our property to build it and to maintain it. In addition to encouraging a trespass, I would submit to the board that it's also really a danger, given the proximity of how high this structure is in relation to the house, and not having any building plans, any evidence that it can withstand the wind loads coming from Katuah Bay. And based on that, would respectfully request that the board overturn the building department's interpretation that what's existing are poles, wires, and burlap, and that what we're looking at is a structure 4x4 cemented into the ground, connected by 2x4s. Thank you.
Thank you, Attorney Schultz. Does everyone on the board have any questions? Inspector O'Neill is not here, correct? I don't think so.
Jake, I have a question.
Go ahead.
Attorney Schultz, I don't want to put you in a position of having to speculate, but what is that structure for?
So it is to protect those giant green arborvitaes. And so the burlap protects it from the wind. And so I did meet with Attorney Gill and the landscaper next door, and we walked through options. And one of their options, and the option that we were more in favor of, was they can simply wrap the trees in burlap, go around in a circle, which will protect them, rather than encasing it in that structure. And they summarily rejected that and said, we're going to do what we're going to do. So there was another way to skin that, but they said no, and to take care of it.
Okay.
And is this temporary or it's permanent? I mean,
My question.
That's a great question. There has been no agreement as to how long it's going to be up. I suppose if it's deemed to be temporary, I mean, I can't imagine that they would want to, in their $15 million house, look at burlap during the summer. So at some point it will come down. And it won't be up year round, but if the building department and the zoning board allow it, it'll just keep coming back year after year.
Because I also look at our definition of tent, a temporary shelter with a framing support, a cloth or similar flexible covering without a fixed location, foundation, or permanent anchors. I mean, you guys are saying it does have permanent anchors and a foundation? Okay. Any other board members have questions?
Yep, I do.
Go ahead.
So I mean, I know it says there's an exclusion there. I would, with the posts being cemented into the ground, it really is no different than a fence. And I don't know if there's a particular height that fences are allowed to be. I mean, it's obviously set up as a temporary structure, but it's not because of the permanence of the poles in the ground. And without a timeline, I don't know how you control that. I mean, but my understanding was that a temporary structure, just like Chair Dewey was saying, was something that was not affixed to the ground permanently in any way. This clearly is, which means it doesn't, to my interpretation, that does not fall into a temporary structure, in which case it would need to be permitted.
But then we go to, okay, foundation or permanent anchors. It's clearly not a foundation. Are these permanent anchors? Are they just, some cement in the ground to hold it down?
I mean, when we do fences, they're permanently put in the ground with cement. I don't know.
Right. And
Height limit on a fence is 6 feet.
6 feet.
Yeah.
So I give you that. A tough one.
Any other board members have questions?
Did
Yeah, I'd like to hear.
Did we get anything from the building department?
Yeah, I'd like to hear from the building department. Present. I would like them to be present.
And also maybe an opinion of an arborist, professional arborist that would say that wrapping, I know that it was one of the options that wrapping.
But that's not what's before us here.
Oh, true.
That's not the enforcement or lack of enforcement here. It's really whether this thing is a structure or it sounds like what Building Inspector O'Neill said is that he classified this as a pole supported by wires, ropes, and burlap, which we are determining that it is or isn't.
Correct.
Excuse me. I didn't see in the photos any proof that the 4x4s are encased or, in concrete, but I also didn't see any guy wires.
Yeah, I was curious on that too. Is there any evidence of this? I didn't go to the site. Is there any evidence of this cement and how substantial it is?
Well, I think the looking at it in comparison to the house and how relatively high it extends, right? We're 20 plus feet. I do have my client, Christine Clark. She's here on the call. I don't have photographs. You have to dig down, right, to open up the cement, the foundation. So it's now covered up with dirt. My client, I'm sure, witnessed that, but extending 20 feet into the air and being interconnected, if it were not cemented, it would not be able to stand up.
Now, what also comes to my attention is when you have the one photo that shows the 2x4 being connected to the building from the post, that pretty much
Exhibit 4
it for me. That was in, let's see, the memo rather than the photos. Prior to this, I had only looked at the photos. I hadn't looked at these.
So I think it was exhibit
in the
1
memo,
to my
but it
letter.
was. Which one was that, Michael?
Exhibit 1 to my letter.
Oh, that yes. There's another one too, I think, but that's attached to the building. How that's a structure.
What building is it attached to, Herb?
It's
It's
attached to what number is that? 698, is it?
It's attached to it. And what evidence is kind of the complexity of the structures is photograph number 4 of the photos that were uploaded.
Okay, number 4.
So that shows the opposite side of what it's connected to.
I think from my perspective, there's a couple of issues here. Number one is if it's not a structure, I mean, what's the definition of a fence? And if it's determined this is a fence, then you have a 6-foot height. So I need to understand what's the definition of a fence versus what's the definition of a structure. And I don't have in front of me the definition of a fence.
I don't believe, Paul, that a fence is defined under zoning. And so looking at 240-128. But a fence, a fence up to 6 feet in height is exempt under zoning, but it has to be limited to 6 feet in height.
Anything else requires a permit.
So, I mean, if it's determined it's not a structure, then it may be a fence. That's what I'd like to hear from the building people.
Well, I mean, we can open for public comment, and then if that's the desire of the board, we can continue and we can request that Commissioner Florence attends the next meeting or sends the inspector that was on this request for enforcement. So let's open for public comment. I don't think we received anything
We did not.
Here, no. Is there anyone here who'd like to speak to this? Okay.
Do I have authority to speak?
Yes. Yep. It's public comment.
All right, thank you.
Just state your name and address for the record.
Thank you. I'm Christine Clark. I live at 978 Main Street here in Cotuit, and I am the person that's asking for an appeal for the ruling. A couple of questions that were asked. The structure typically goes up in November and comes down in May, which is about 6 months, so about half of the year. And for me, it's a large structure in my front room. As you can see, it closes off the first and second floor windows. So it's a very large amount of burlap for 6 months of the year. It's also a concern for us if the wind blows and maybe one of the levels of the structure falls through the windows, because it goes from the first floor windows all the way up to the second floor windows and puts the whole part of the house in behind a blanket of burlap. My biggest concern is I really wanted to reach out to the neighbor and have conversation and really wish to work with them on this particular issue. The trees are going in for screening purposes, but as you saw, there's two lines now of green emerald arborvitaes, which grow to about 16 to 18 feet tall. So on the level of my neighbor, they have an entire line of arborvitaes going across. Then you have an 8-foot wall. And then within that little 14-inch property line, they're trying to, they put in another line, an equal length of line of another row of trees. So for me personally, that's excessive amount of screening material that's needed when you have to have 2 rows of trees plus a wall. So I'm the one that's actually requesting that we reconsider the nature of this structure. And I'm very happy to work with our neighbor as far as any tree protection or any screening, privacy screening needs. But unfortunately, I'm not able to get through. Yeah.
Okay.
And
Thank
again,
you.
As Mr. Schultz did, Attorney Schultz did mention, which is not part of this issue, is that the plantings are definitely on our property now with the large root balls. And so all of my hydrangeas are being completely crushed, and obviously they're killing them off. So that's a whole separate issue outside of the structure issue. But so it's been very disappointing because we're new neighbors and we're here full time. We live here year round. And so, yes, it's been challenging.
All right. Thank you. Is there anyone else here from the public that wants to speak to this? All right. What's the desire of the board here? Do we want to make a request to Commissioner Florence that he attend or send the enforcement officer to the next meeting? Or to someone, before I close, we still need to close public comment, but I would leave it open if we're going to continue.
I'd like to hear from the building commissioner's office.
I agree. I don't know how we can proceed without getting their perspective. I mean, that letter seems inconsistent with the pictures.
All right. So I can make a motion that we continue this to April 9th, 2025. Do I have a second?
Paul, second.
Sorry, Attorney Schultz, go ahead. Is that acceptable time or?
Oh, it is. Yes.
Okay.
Thank you.
All right. So roll call vote on continuing the appeal to April 9th, 2025, and public comment is still open on the item. Herb Bodensee.
I'm in favor.
Paul Pinard.
In favor.
Mark Hansen.
In favor.
Rodney Tavano.
In favor.
And I am also in favor. So we will continue this. Anna, do you mind reaching out, or I can reach out to Commissioner Florence and work with his department?
Sure, I can.
Okay. All right. So that is our last appeal for the night. We had correspondence, a bunch of correspondence from the Cape Cod Commission. There was a meeting about the Witchmere Hotel expansion, March 14th, 2025. There was a continued hearing notice for the hotel expansion to March 27th, 2025. We got a hearing notice for Captain Birdie's Way housing project. That's March 31st, 2025. A pro forma hearing for Captain Birdie's housing was March 17th, 2025. A RPP meeting agenda for March 19th, 2025. An executive committee meeting agenda for March 19th, 2025. And a meeting agenda for the Witchmere Hotel expansion for March 24th, 2025. Any matters? We'll go to discussion item, in-ground pools and setbacks. Natalie had made some sort of comment about this. Is it something that repetitively is coming to us? Town Councilor Ludke is here. We had also talked about it a little bit, but I would defer to Town Planner Kupfer to maybe give us a quick sort of like background here. Sorry, Jim, I did not get a chance to give you a call to sort of pre-discuss this, but it's just something we're seeing a lot with these pools inside setbacks, considering them structures, and it's something we just would like to know if the town and the community would like to have these pools permitted or allowed, and if there is, should special permit provisions be made to make a path for permitting for them.
Yeah, certainly. Thank you, Chairman Dewey. We can certainly have that discussion, and potentially we do that in more of a workshop format, maybe with this zoning board of appeals or a separate entity. But ultimately, I think what we want to define is what goals are we trying to achieve here? We have an existing 100-foot setback that is along 28 and 132. And that is for, there's likely many reasons for that, but one of them is to preserve tree canopy and that setback from, the busy corridors. So there is some rhyme and reason to that 100-foot setback. However, we certainly could look at carving out accessory structures. And I know Commissioner Florence and I have actually had a lot of discussions about this and trying to formulate a separate section of the ordinance for accessory structures. So maybe that's our best approach is coming back to you with some suggestions as to accessory structures, including things like pools, or I think we're talking about things like basketball courts and tennis courts and et cetera, that might not need to adhere to the full setback, but still have a degree of setback, because I know you guys also hear from time to time someone and a butter perhaps that maybe is not inclined or not appreciative of reduction of that setback. So there is a lot to consider in terms of what impacts may be created and why those setbacks are there. But I'm happy to hear any comments, concerns you guys have that can give us some direction, because right now along 132, 128, yes, 100-foot setback, and then obviously in other various areas, you have to adhere to the principal structure setbacks, which is typically 10, 15, or 20 as you typically do. So happy to hear any suggested comments.
Yeah, I think it's not just that the one that was on 28, 132. It's sort of all of them. It seems to be a trend that people are trying to put pools in their backyards on these small lots in all parts of our town. And so it's just a matter of, should there be some sort of provision where, maybe it is a special permit, it still comes to our board and we have some, guidelines to it of different things that are important when a pool goes in next door, that it's not disruptive to the neighbors in the neighborhood.
Right.
Right now, the only path is a variance, correct? Right? That's really the only way for someone to do that.
Correct. That is correct. And so I guess the question is, do we want to be more lenient? And if so, then yes, we certainly can work on some regulations for that or an ordinance for that. But, do we truly want to reduce those setbacks for those types of uses?
Yeah, and that's a question for the town council, I think, to take up and have a robust public process of deciding that.
Yeah, I also remember we've had some cases where, I guess under existing rules, pool is considered lot coverage,
Right.
which in at least one case has caused the denial of a pool request. Secondly, what is a pool? Now, all pools have aprons. Some are just the pool itself, which may be a foot. Others may have 5 or 20 feet of an apron. So the question comes in, what's a pool? I can remember when I had a house in New Jersey, the rule was if you wanted to build a deck and it was attached to the house, then it was part of the rules and regulations of zoning. If, however, it was not attached to the house, it was as of right. And so I built a very large deck an inch away from the house. and so, again, relate that to pools. You can have a wood deck around a pool that's not attached to the pool, and is that considered lot coverage? Or so that's why I'm not sure the definition of a pool, particularly when it pertains to lot coverage and setbacks.
Yeah, and we'd need to know that with the growing popularity of plunge pools, which can both be close to the home, they probably are not more than 3,500 gallons, something like that. There is actually a gallon calculation between a pool and a hot tub. I don't know what it is per se, but I agree with Paul that a lot of times we had the lot lines were not the issue. It was the FAR. It was, that included, was it a landscape feature or was it a structure? That's, was the question. And do we want to put size limitations based on, the lot size? If you can't put an 18 by 31 pool if it fits in and have no lot coverage rules, but maybe there's a percentage allowed, over and above the lot coverage that is relative to the size of the lot and the size of the pool. So if you have a smaller yard, maybe you can only put in a plunge pool, or people oftentimes don't want to reduce the sizes. So I think size versus total lot size and coverage is important. But I agree with Paul. Is it a structure? Is it a landscape feature? What is it? Or when does it become a structure?
Oh, this is a little bit of a deja vu for me because I used to sit on Board of Appeals in the town I used to live in, and we went there through this process and went from having a variance being the only route to actually doing a special permit, and a lot of these issues came into it. And I think because the one case I remember that we disallowed, basically the pool was going to encroach, I don't know, a matter of inches or something, right, into the setback, but the applicant could not meet the variance requirements. I mean, you can't. What sort of hardship are you into if you can't have a pool, right? It's so. I think that more and more of those come up where you sort of feel for the applicant, but in a way, our hands are tied by the variance rules.
Yeah, and I mean, you guys play a very important role in that we have laws in place, and you all must review each and every application and match that with the law. And those laws are in place to limit or protect the health, safety, welfare of our community. So, again, I think the question may be one of the actions we can do is better define each of these. I mean, I heard from that previous case, there's certainly some tightening up of definitions that we certainly could do. But then I think the next question that maybe we do through some sort of public engagement or workshop format is, do we want to, provide opportunities for reduced setbacks of accessory structures, and in what format? That could be by special permit, or we just have different standards for accessory structures, perhaps. Because I mean, you do walk that fine line of trying to help out individuals and neighbors, but we do that with potentially adding maybe a little bit too much to the neighborhood on these small lots, potentially, and so because we get that feedback a lot as well. So yeah, I'm happy if the board wishes to work with the building commissioner, and maybe we can formulate maybe a subgroup of folks to work on this if you want, Mr. Chairman.
Yeah, I think so. Natalie, you sort of took the first lead on it. So do you want to sort of
Well,
put
no, I
together
mean,
a subcommittee with
yeah,
Jim?
for the last case that we had, I kind of felt bad for the petitioner because she had paid her money, and not that that will be a lifelong problem, but just that it was, and then you guys all said it was automatic. She wasn't going to get the approval. So that's, I mean, I just think that maybe we shouldn't be accepting people's money until we get it squared away as to what we're going to define it as. I mean, I would be unhappy if that were me, even though, I mean, it doesn't meet the financial hardship. So maybe you're out $1,000 by the time you pay the architect or the zoning people, land people. So I don't know. I just think that we should have some definite regulations that we can use to go forward and not take people's money until we do.
Well, I'd be glad to help, Jim, if you need somebody.
And I might also suggest, if we do want to go down this road, that maybe we investigate briefly, are there any relatively surrounding towns in Massachusetts that already have provisions in their bylaws? Like, I don't want to reinvent the wheel necessarily.
Right.
I can't imagine our circumstances are so grossly different than anywhere else. So if someone could give us a head start, that might be just an hour on the phone, just calling some of the.
I did that survey for withdrawals and continuances, and I surveyed all 15 towns of the Cape, plus major cities, plus other cities in the state. So
right.
You're right, Mark. That's a real good. Don't reinvent the wheel if you don't have to. So I could. Well, anyway, Jim, if you need some help, I'm available.
Yeah.
So Jim,
Mr.
would
Chairman,
that work? Natalie and Paul, and do you want a third or?
We can start with Natalie and Paul if you'd like. And
Need a third, I'll put my hand up.
Okay, excellent.
With open meeting law, if it's three, then do we have to have published meetings for the four of you to meet, or?
We would either way. It's a subcommittee, so I would publish that we're meeting either way.
Okay.
And so yes, but what I can do is, why don't I start with looking at some other options, seeing what others are doing, but do a little legwork first, and then I'll reach out to the three that have volunteered, and I can work through them to set up a subgroup to maybe bring something back to the full board at some point soon.
That's a good idea.
Good.
And then Jim, just for process, so we would sort of craft something, and then we would have to go to town council to ratify it,
ultimately depends on what the end result is, then deliverable. If we want to change an ordinance, absolutely, yes, it would go through just as defined under Mass General Law 48, Section 5, which a petitioner, which could include zoning board of appeals, actually listed as one, that could move it forward. It would go to town council for a first read, then to the planning board for a public hearing, where the planning board is really the avenue where a lot of public discussion may happen. And then it would ultimately go to town council for a determination as to whether or not they want to adopt that ordinance.
Okay, but we as the board could be the sponsor of it. Basically.
Yes, that's correct.
Okay.
That's correct.
Okay.
Good.
No, I think that's great. And everyone, with any things we have coming forward, keep that in mind. If there's things we are seeing repetitively that we think should be addressed and updated, we should do that. It's part of our task.
Good.
Maybe a discussion for some other time, but something that comes to mind is the ordinance relating to signs.
Yeah.
We should have maybe that conversation at a different time.
Yep.
Okay.
All right. Thank you, Jim, for being here, and look forward to trying to sort of put that together. One other item, just reminder of everyone. I don't know where everyone's conflict of interest training is, but I believe it's every 2 years we have to renew it. I just renewed mine last week, so just a reminder. And upcoming hearings, April 9th.
So, Jake, sorry, I missed that one. I got the harassment one, but there was a training for conflict.
I believe, Anna, we have to do our conflict of interest every 2 years, correct? Or Jenna? Is Anna going?
I believe so. Jenna, do you remember?
Yeah, it is every 2 years, and I think Jenna or Anna put out a schedule as to when we were up or when we, when we need to do it.
It's monitored. I'm pretty sure the latest update is that it's monitored by the state now. It used to be monitored by Cindy Lovell. So I think the state automatically sends out email reminders. I could be wrong. I'll double check with Cindy tomorrow about it.
I think they will now going forward because you have to set up an account now. But I don't know our previous. I don't think we're going to get a notification of 2 years. I just had it in my calendar, but I don't think we're going to get a notification for the last one. So we might just want to check with Cindy on where we all are with that. And then going forward, yes, I think the state will remind us.
Thank you.
So upcoming meetings, April 9th, 2025 is in person. April 23rd, 2025 is planned to be remote. I don't know where we are with the state law. Anna, are we not looking?
We don't know at the moment.
Okay. And then May 14th, 2025 is in person.
And I will not be in attendance for the 9th.
Okay. I'll make a motion to adjourn unless anyone has anything else.
Yep, second.
Roll call vote. Herb Bodenseek,
Favor.
Paul Pinard,
In favor?
Mark Hansen,
I'm in favor.
Larry Hurwitz,
Left.
Manny Alves,
In favor.
Rodney Tavano,
Favor.
Natalie Pittenger,
In favor?
and I'm also in favor. So we are adjourned.